Well, welcome to the show. I am your host, Daniel. And of course, I want to welcome any new subscribers to this channel. And if you like this content, please do me a big favor and let's help this channel grow. And by subscribing, it doesn't cost you anything. Just click subscribe and hit all notifications. That's it. So today is Judge Aaron Gauthier. I like this guy too. There's quite a few judges I like. So let's get started doing this, and let me share my screen. And let me make it bigger, of course.
Be on Zoom. Good morning on Zoom. Can you unmute your, okay, can you tell me your name, sir?
Cody Young.
Okay, and I've got Mr. Johnson zooming in. Let's pull him in here. It's on page 3. All right, good morning, Mr. Johnson. How are you, sir?
I'm doing good, John. How you doing today?
Great. You got that car parked yet?
Yes, sir.
All right, very good. All right, this is People v. Cody Gillen, file 25-93363FH. And we've got Mr. Johnson for the defense, Mr. Gillen appearing by Zoom video. Who's for the people on this one? Okay, Mr. McClellan. All right. And I did see that there had been a pending motion for substitute counsel, but it looks like the Office of Assigned Counsel internally just reassigned that at defendant's request. So Mr. Johnson's newly into the case. That renders that motion moot. And we're here for a docket call. And also we have the prosecutor has filed a motion to adjourn the trial, which is currently scheduled for February 5th and 6th. So I guess, Mr. Johnson, is there any resolution of this case? Or are we still on the trial docket? And do you have any objection to an adjournment of that trial?
Your Honor, first I was retained, not appointed.
Oh, okay. Very.
I did receive, and I've talked to the prosecutor about the adjournment of the trial. We have no objection. Also, an offer has been made that I still need to talk to my client about. There's some collateral consequences we need to figure out. So if we can have another docket call day prior to the trial date, Your Honor, please.
Okay. Well, what I could do is why don't we do this then? We'll I'll cancel the trial date on February 5th and 6th. I assume you still want that date. The reasons for the adjournment haven't changed then?
Correct, Your Honor.
Okay. And let's come back for a docket call on February 2nd at 9:30. And Zoom appearances would be fine for that, Mr. Johnson.
Thank you, Your Honor.
And do you want me to leave trial date unscheduled at this point, and then on the second, if it's not resolved, I'll give you a firm trial date at that time?
That's fine, Your Honor.
Okay. Any objection to that, Mr. McLennan?
No, Your Honor.
Okay. Well, then with that, anything further from the defense, Mr. Johnson?
Yeah, I just want to confirm that the court got the defense witness list, although the trial date is, we don't have a trial date yet. I just want to confirm that.
You know, I do not see that. Is it in your file? Let me just double check if the court's got it.
Defense witness list.
Yeah. Okay, yes, we do have the defense witness list.
All right, thank you, Your Honor. Nothing further.
Okay, anything further from the people?
No, Your Honor.
Okay, Mr. Gillen, Johnson, we'll see you next February 2nd at 9:30 a.m. And we can give you a firm trial date at that time if necessary. The prosecutor's motion to adjourn the trial is granted without objection. All right, thank you. All right, have a good day. You too. We have here in the box. Are we zooming anybody in from the jail, or do we bring them all of this?
There is Zoom at the jail also, Judge.
Okay. All right. Is Alicia Dockstader?
Yep.
Okay. Is there anybody covering that for counsel? Okay. We'll call that case. The Alicia Dockstader, file 25-93382 FH. For arraignment, and 24-93008 FH for probation violation hearing. Counsel, you want to state your appearances, please?
Jeremiah Buffalo Wars on behalf of the people.
Your Honor, Mike Kogler, I am here this morning. I anticipate representing Ms. Dockstetter once the court signs an order appointing counsel.
Okay.
As you know, maybe you don't know
I did hear that her counsel had passed away.
yet. I can just approach with that. She's filled out the request for counsel. I reviewed it. I think she was certainly qualified.
And do you want this to include the new file and also the probation file then? You want me to add that on?
I represent her on the probation file
Oh,
already.
okay.
This should be the new file unless I mixed up the numbers.
No, you got it. All right, thank you. So for purposes of arraignment, have you had a chance to review the charging document?
Yes, I went over that with Ms. Dockstetter last week.
You or she wish to have its allegations read?
No.
And how does she wish to plead to its charges?
Your Honor, at this time, she'll stand mute.
Who on her plea of not guilty on her behalf to the charges in the information of unlawful imprisonment, domestic violence third, interfering with electronic communications, vulnerable adult abuse. And there's a habitual second notice that's been filed. Is a forensic center referral requested?
No.
Estimated length of trial?
I would say 3 days, Your Honor. Hedging my bets.
And we can put it for docket call February 2nd at 9:40. And Mr. Vogler, do you want us to continue the probation matter as well?
Yes, Your Honor.
So we'll adjourn the probation matter 93008 to the same date and time schedule this for docket call and probation violation hearing February 2nd at 9:40 a.m. Anything further from the defense?
No.
For the people?
No, Your Honor.
Okay, we'll see them this time. And is Mr. West in the back?
He's the one at the jail, Your
He's
Honor.
gonna zoom.
Yep.
Ms. Fisher?
Yep.
Looks like this is two files, 21-93178 for a docket call and 25-93385FH for an arraignment. Counsel, you want to state your appearances?
Jeremiah Buffalo, work on behalf of the people.
Your Honor, Mike Vogler, I represent Randy Fisher in both files.
The new file for arraignment, have you had a chance to review the charging document with your client?
Yes, Your Honor.
Do you or she wish to have its allegations read?
We would waive the reading of it.
And how she wish to plead?
Your Honor, she will plead not guilty.
Under a not guilty plea on the charges of, looks like a UDAA and a forged title. Is a forensic center referral requested?
No,
Estimated length of trial?
I would say a day.
Agreed, Your Honor.
Appropriate for a docket call February 2nd at 9:50.
Yes.
And Mr. Vogler, would you like the other matters scheduled for the same date and time then?
Yes, Your Honor.
Anything further from the defense? Anything further, Mr. Vogler?
No.
Anything further, Mr. Virgo?
No, Your Honor.
Okay, you're all set, Ms. Fisher. Are you Mr. West? Are you Lyle West?
Yes, sir.
All right, People v. Lyle West, file 25-9333FH. Counsel, you want to state your appearances, please?
Zachary McLennan for the people.
Hey, good morning, Your Honor. James Gilbert here on behalf of Mr. West.
Morning. You had a chance to review the charging document with your client?
Yes, Mr. West is fully aware of his charging document.
All right, do you or he wish to have its allegations read into the record?
We'll waive the reading, Your Honor.
And how's he wish to plead?
He's going to stand mute.
We're going to plead with not guilty on his behalf to, looks like a charge of felonious assault, an R&O, altering firearm marks, and domestic violence. It's a forensic center referral requested.
It is not.
Estimated length of trial.
Right, 2 days.
Call February 2nd at 9:10 a.m. Anything further from the defense?
No, Your Honor.
From the people?
No, Your Honor.
Okay, we'll see then, Mr. West. All All right, and Mr. Vogler, we also have an arraignment in People v. Antoine Zeno.
He's in the jail also, Your Honor.
Oh, is he? I didn't
I
notice.
believe he's in the jail, yes.
Okay.
If you need him brought up, I can.
No, we'll pass on that. He can come
Okay.
in. All right, well, let's call then,
I'll have him put in the box down there.
Mr. Voida, we'll call Mr. Beck's case first.
Yes, Your Honor.
Versus Theodore Beck, file 25-93365FH. Counsel, you want to please state your appearances?
Zachary McLennan for the people. Nat Boyd for Mr. Beck, Your Honor.
Okay, and I did speak with counsel. In chambers about the timing of some new charges being filed, and it looks like that's we're on the verge of that happening in the next week or so. Is that right, Mr. McLean?
Correct, Your Honor.
All right. So, Mr. Voida, any objection to a continuance of this to February 2nd at 10 a.m.?
Your Honor, 10 a.m. I would ask for a different time.
Sure. What time?
I am scheduled to be in the sentencing in Iron Mountain at 10:30 that morning.
Okay.
So I would ask that it be either a little earlier or a little later than that so that I can handle this hopefully by Zoom if the court would allow.
Yeah, I could do it right at 9 a.m.
Okay, 9 o'clock, very well.
February 2nd, 9 a.m. And we still have status conference on the pending bond violation. We'll just continue. And since there have been no further problems, we'll allow Zoom appearances for the next hearing as well.
Thank you, Your Honor.
Anything further from the defense?
No, Your Honor.
Anything further from the people?
No, Your Honor.
Okay, Mr. Beck, we'll see you by Zoom February 2nd at 9 a.m.
Your Honor, Mr. Zeno should be in the library.
Are you Mr. Antoine Zeno?
Yes, sir.
It's file 25-93384FH for arraignment. Counsel, you want to state your appearances, please?
Jeremiah Buffalo, we're on behalf of the people.
Your Honor, Mike Vogler representing Mr. Zeno.
And have you had a chance to review the charging document?
Yes,
Do you or your client wish to have its allegations read?
we do not, Your Honor.
How's he wish to plead to that charge?
Your Honor, he's pleading not guilty.
Okay, we'll enter plea of not guilty to the charge that looks like an assault by strangulation, an assault and battery, and a domestic violence. Is a forensic center referral requested?
No.
Estimated length of trial?
1 day, I would think.
I would agree, Your Honor.
But, yeah, we can go ahead and do some type of probation stuff today and get this out the way so I get back to work. I mean, I don't have no kind of conflict or anything with the person. We still friends. It just, the little bullshit that happened with that. And I mean, I'm ready to get back to work.
There you go. Mr. Zeno, I have muted you at the request of your attorney because you're starting to talk about the facts of the case, and he certainly doesn't want you to do that. And we can't just put you on probation today. You're presumed innocent. I can't do anything with you other than address bond questions. We can have a jury trial, we can have a trial to the judge, or we can have a plea or a motion to dismiss. Those are kind of the ways that we get to the finish line, not just because you want it to move along. So we'll schedule this for a docket call on February 2nd at 10 a.m. And if you want to schedule at that time for a jury trial, I'll certainly give you one, Mr. Zeno. And I'd encourage you to talk with your attorney, and then through your attorney, you can bring anything to my attention that you'd like to, all right? Anything further from the defense?
No.
From the people?
No, Your Honor.
All right, you have a good day, sir. All right, and Mr. Voida.
You're on the hallway, Your Honor.
Mr. Boyd, are we ready with Mr. Kubik?
Yes, Your Honor.
It's will be Larry Kubik, file 24-93307FH. For sentencing, counsel, you want to state your transfers for the record, please?
Zachary McLennan for the people.
Matt Boyd from Mr. Cubic.
And we have Agent Lesky in the courtroom as well with the sentence report. We're here for sentencing on a charge of operating while intoxicated, third offense, statutory maximum 5 years, guidelines scored at 7 to 23 months. Mr. Boyd, do you have any additions or corrections to the pre-sentence report?
We do not, Your Honor, nor do we have any challenges to the scoring of the guidelines.
Mr. McLennan, any additions, corrections, or scoring challenges from the people?
None, Your Honor.
All right, and Mr. Boyd, any elocution you want to make?
Yes, Your Honor. I know that there's an agreement in this case for a cap of 13 months. And I can understand certainly the reasoning behind the idea that my client needs to spend some time in prison in this case. When you look at his prior record and you look at the level of alcohol, I totally understand that. And I can understand the logic of the trip to Jackson being impactful and leaving a lasting image that will hopefully set him on the right path. And I believe that such a sentence would be proportionate to the offense and the offender. However, when I look at the circumstances here, I think that there's a range of proportional sentences here. And under the circumstances, my client is now almost 2 years sober. And verifiably sober with SoberLink and a Scram tether on it. He has set up a foundation for future success through meeting with counselors and going to a meeting twice a week for 2 years. And so while I totally understand and agree that the shock of a trip to Jackson and wherever the road might lead after that would deliver a strong message that would hopefully be heard, I think the message has already been delivered and received here without the need for that. That's not to say that Mr. Kubik doesn't need to spend time behind bars. It's not to say that you would be wrong to sentence him to a term of prison. But I think the appropriate sentence, considering the factors, considering the good work that he's done over 2 years, is at the low end of the guidelines here, and that's what we would ask you to do.
Thank you, Mr. Boyd. Mr. Kubik, you don't have to make a statement today, but you're allowed to. Is there anything you want to tell me, sir, or no? That's fine. Mr. McLennan, any recommendations from the people?
Your Honor, we did previously allocute at our last sentencing hearing and it reached the agreement for a 13-month cap on prison time based on the circumstances stated previously. We are in support of that. Thank you, Your Honor.
Thank you, Mr. Kubik. If you please stand for the court sentence. In this case, Mr. Kubik, there has been, it's taken some time to get to this day, partly because there was, as you're absolutely right, a motion to challenge the constitutionality of the stop, and then that motion was denied, and you took an interlocutory appeal, and that slowed it down some, and that appeal was denied as well, and then there was a plea with a 6-month cap, and we got to sentencing, and I said I wouldn't do that. In fact, I expressed that I was inclined to sentence you at the top end of the guidelines. So you withdrew the plea, which is your right, and I think it was on the day of trial or the eve of trial, we entered a different plea agreement with a 13-month cap. And in this case, I still think a prison commitment is appropriate, Mr. Kubik, for a couple reasons. One, it's your true 5th drunk driving conviction. You were first arrested at age 54 and you're only 61 now, and all your arrests have been alcohol related. In 2018, and impaired in Alpena. In 2022, an OWI plus possessing a gun in Alcona. And you failed to attend treatment then. 2022, an impaired in Iosco, treatment in lieu of jail. 2022, a Wayne County OWI arrest at a .29, and then that was dismissed when, along with a probation violation sentence you got in another county. Again, in 2022, an OWI in Aranac. And then in 2024, this offense, you had been released from jail only 4 days before. And at 11 a.m., we're driving at a .29, .30 blood alcohol. So you're just on, this path of so many arrests, separated only by, 3-4 years each time. And treatment has been tried. It hasn't worked. Some jail has been tried. That hasn't deterred you. I think the time has come for you to get a little snapshot at you're 61 years of age. Lord willing, you got another 20 years or so in you. What do you want those 20 years to look like? In and out of jail or prison? Probably not. I mean, you made it to 50 without getting arrested. That was probably better than the last 10 years have been for you, be my guess. So I hope you get back to that pre-50-year-old mindset and not be in and out of court and getting arrested. But I think it is time to clearly communicate to you what your future is going to be like. Your future will be spent behind bars unless you make radical changes. I do think it's a proportionate sentence. It's within the guidelines. I'm going to commit Mr. Kubik to the Michigan Department of Corrections for a term of not less than 13 months, nor more than 5 years. Give him credit for 3 days previously served. There's a crime victims assessment of $130, court costs of $350, OUIL reimbursement of $200, state cost of $68, and I'm also going to assess a $500 fine. And Mr. Kubik, if you want, you can file an appeal to the Court of Appeals to challenge your conviction or my sentence or both. If you want a lawyer appointed for you and you qualify, you'd have to make that request within 6 months of today's date. We're going to hand you a piece of paper explaining that appeal process, ask you to initial one copy for us. Fill out the other one if you wish to take any appeal. And good luck to you, Mr. Cooper. And who else do we have in the box here?
Mr. My counsel isn't present.
Oh, counsel's not present yet?
Yeah. Where's your counsel?
Mr. Park, Mr. Parks. Yeah. No, it's Does that conclude your matters, Mr. Boyer?
It does, Your Honor.
Okay, you have a good day. All right, and we have up next the probation violation arraignment and people be Joe Green. File 24-93344FH. Counsel, you want to state your appearances, please?
Your Honor, I'm appearing as the arraignment attorney today. I wasn't aware of that something was going on until I looked at the docket. I have a charging document. Neither does Mr. Green, apparently.
Oh. I can let you borrow mine, and we can pass the case.
Sure.
All right, I'm back on the record recalling People v. Joe Green. Mr. Green, it's alleged that you are, this is a child support case, and it's alleged that you're in violation of your probation by failing to make regular payments on your child support case in the divorce action, and also by failing to attend substance abuse treatment and not maintaining legitimate employment. Those are the first 3 counts. Those are technical violations of your probation. If you were found to be in technical violation, 1 violation is a maximum 15 days in jail, 2 violations is a maximum 30, 3 violations is a maximum 45 days in jail. And it's also alleged that you violated state law by using methamphetamines. Actually, with this being not an OWI 3rd case, that would actually be a technical violation as well. So if there's 4 technical violations, then the court could revoke your probation and sentence you on the underlying case, which is failing to pay child support, which is a 4-year, is that a 4-year? Yes, a 4-year felony. Mr. Green, do you understand the maximum penalties that you could face?
Yes, sir.
Okay, now you do have the right to have a hearing on all these allegations where they would need to be proven by a preponderance of the evidence. You have the right to the assistance of a lawyer. And if you request assigned counsel and qualified, then you have counsel at public expense. You can present any evidence you want at that hearing, and you can cross-examine any witnesses that are presented against you. Although the rules of evidence don't apply at probation violation matters except as to privilege. Do you understand the rights that you have, Mr. Green?
Yes, sir.
All right, Mr. Vogler, do you know how he wishes to proceed?
Your Honor, he has informed me that he wants to request court-appointed counsel before proceeding any further.
Okay.
I have the forms with me. Clerk's office would have those. I could have him fill it out before he leaves this morning. if
Yes,
he's allowed-
that'd
if
be
he's allowed to
fine.
leave.
And then let's see. I'll enter a plea of not guilty. And Mr. Green, you know, I guess I just want to tell you in a child support case, you know, it's my sincere hope that we don't end up having to give jail to you. So what I'd like to see happen here, whatever's going on, if these violations are happening, I don't want you to tell me if they are, but if they are, I want to see what you do to correct them. You know, making payments, get yourself a treatment, you know, get a job, communicate with your probation officer. You know, I want to see you succeed on probation. Locking you up doesn't help the child support one bit. Right? But you keeping a job and not using methamphetamine is going to help you pay child support. So I want to see those things happen. So we'll enter a not guilty plea. We can schedule it for probation violation hearing February 2nd at 10:10 a.m. And Mr. Vogler, if he does qualify, do you know to whom it will be appointed?
I would be taking the case then.
All right, so Mr. Green, fill out that form, and then do you want him to bring it back in here then?
Yes.
Okay, then bring it back into Mr. Vogler. Okay. And then once you do that, then you're all set to go. Let's call People v. Docket. This is file 25-9374FH. Counsel, you want to state your appearances for the record?
Jeremy Buffalo, work on behalf of people.
Good morning, Your Honor. Christopher Parks on behalf of Mr. Gauthier, who stands to my right.
We're here for sentencing on a charge of felon possession, 5-year maximum, 0 to 11 guidelines range. And domestic violence, a 93-day misdemeanor. Have you had a chance to review the pre-sentence report and recommendations, Mr. Parks?
I have, Your Honor. I went over them. I took a copy to the jail, went over those with my client. The only issue we had, Your Honor, was to the amount of jail credit. There should be an extra 6 days on there, Your Honor. He should have a credit of a total of 70 as he was arrested before the actual offense date. He spent 5 days in before the date of offense of 10.
Well, hang on a second. The offense occurred on 3/10. How would he get credit for time prior to when he committed the crime?
Your Honor, the offense actually occurred 5 days prior to that. He was incarcerated for those 5 days. He wasn't actually arrested until the actual date of 3/10, which is listed on the report.
Well, it says he was arrested 3/25.
Second time, Your Honor.
Mr. Virgo, you want to help me out?
Your Honor, there was an issue of evidence relative to the firearm that was not discovered until after the initial arrest on regular domestic violence.
So he spent 5 days on that?
I don't have the number in front of me, Your Honor, but I take counsel at his word, and I know that he did spend some time on that project before that.
All right, so you have no objection to him getting credit for that time?
It would be appropriate, Your Honor.
All right, so we'll amend it then to
It should be 70, Your Honor.
70 days. Okay. All right, any other additions, corrections, or scoring challenges?
Not from the defense, Your Honor.
Mr. Virgo from the people?
Significant, Your Honor. I don't believe the probation department had the benefit of the knowledge of the post-plea, pre-sentencing contact with the victim in this case that makes the basis for the show cause. The people request that we adjourn the sentencing based on that because there is significant chance that that constitutes post-plea misconduct and would impact the sentencing agreement in this. Further, Your Honor, I do believe that I only have transcripts of those calls right now. I do not have the actual audio yet, but based on those transcripts, I do believe that some new charges would potentially be forthcoming.
Well, there wasn't a sentencing agreement though.
We bandied about a lot, Your Honor. I might be missing on that, but still, I do believe that the content of those.
So you want to address the alleged contempt before we decide on the sentence?
Yes, Your Honor. I do believe that it is directly germane to the sentencing as.
Well, let me bring on that then, because that was one of my questions is, well, we're here for sentencing. Do you want me to just dismiss that? But apparently not. So Mr. Goddard.
Yes, sir.
It's alleged that you are, who are you looking at back there?
My wife, sir.
Do it again.
Anything, all I do is turn around. I'm sorry.
Do it again and we're going to have major problems. Mr.
Okay.
Eyes up on me.
Sir.
It's alleged that you're in contempt of court for violating court orders by having contact with your wife and attempting to influence her with her testimony. That would constitute a contempt of court. The prosecutor is considering whether to charge you with additional crimes. From the eyes up at me.
I'm looking.
On the contempt, I could give you 93 days in jail or $500 fine, $7,500 fine, or both.
Yes, sir.
Also, of course, that would impact what I might want to do on the sentence here that you're standing in front of me for. Do you have the right to have a hearing on that allegation where your contempt would need to be proven beyond a reasonable doubt, and the right to the assistance of your lawyer? I'm going to enter a not guilty plea for you. I don't want you to plead guilty to a contempt or anything because the prosecutor's thinking about new charges. So we'll enter that as a not guilty plea. And Mr. Parks, you want us to schedule that then for a contempt hearing, sir?
I guess, Your Honor, yes. Yeah.
So let's schedule this for a contempt hearing February 2nd at 11 a.m. I don't want you looking anywhere to the side or behind. February 2nd at 11 a.m., contempt hearing and continued sentencing. Let's get Mr. Goddard out of here.
Yes, Your Honor.
If I may, Your Honor.
Welcome to.
Yeah,
The people request no phone privileges while in jail except for witness counsel.
granted. Phone privileges revoked except to his lawyer. Submit an order to that effect.
Yes, Your Honor.
Mr. Parks, we also have people be twos that have been continued.
May approach, may we approach, Your Honor?
All right, back on the record, people be twos, it's a 1989 case, 91188, motion to set aside. And I've talked with counsel a couple times. There's some legal wrinkles here. And Mr. Parks, you've indicated that at this point you want to withdraw that motion and refile it perhaps at a later time once those issues are resolved.
That's correct, Your Honor. Discussing the matter with MSP as well as the Attorney General's office. One of the charges that Mr. Twos is seeking to have expunged, the Attorney General's office believes that it should have already been expunged automatically with the change in the marijuana law. We're waiting on MSP to kind of tell us why it's taken so long to get it off of his record. As soon as we can figure that out, then we'll be refiling, Your Honor. But at this point, it's better just to get it off the court's docket.
Okay, if you want to submit something in writing then withdrawing that motion without prejudice, then we can close the file.
Very well, Your Honor. My staff is already preparing that.
Okay, thank you.
Thank you.
Mr. Vogler, has Mr. Green filled that out?
Yes.
I'll find that it does qualify and refer it to the Office of Assigned Counsel for appointment. You're all set then until the February 2nd at 10:10. All right, Happy New Year, Mr. Funk.
Happy New Year, Judge. Beautiful day.
Yes, indeed. All right, people be Ricardo Harris, file 25-93380FH. Counsel, you want to state your occurrences, please?
Jeremiah Buffalo, work on behalf of the people.
Dave Funk, P26715 on behalf of Mr. Harris. Can you see Mr. Harris on the video, Judge?
Indeed, I can.
Oh, okay, thank you then.
All right, and we're here for a docket call. What's our status in this matter, Mr. Funk?
I'll leave this up to Mr. Wirgo, who called me this morning and had some comments to make on our status.
Yes, Your Honor. Defense counsel very diligently has been on top of this case. We did believe we had a resolution going. As of this morning, there are some new facts that have come to light that may impair that resolution. We really need to get a handle on those before we could resolve this, Your Honor. This is, again, I want to make clear to the court, this is not a lack of work on behalf of anybody.
Okay. All right, any objection to continuing this then, Mr. Funk, to February 2nd at 10:30 a.m.?
I have no objection, except February 2nd, I'm due for brain surgery in Petoskey.
Oh, okay. You available on March 2nd?
Yes, sir.
Okay. All right, let's do March 2nd at 10:30 for a docket call. And I'll allow Zoom appearances and Anything further from the defense?
No, sir, other than drive carefully today. It's nasty up there.
Yes, indeed. Anything further from the people then?
Just my well wishes to Mr. Funk, Your Honor.
Okay, yes, yes. Best wishes to you, Mr. Funk, and we'll see
Thank
you in March then.
Thank you, sir, very much. Have a good day.
You too. All right, Mr. Gilbert, we've got docket call on Mr. Chapman.
Yes, sure.
It's file 95-93379FH. State your appearances, please. Begin with people.
Zachary McLennan for the people.
And good morning, Your Honor. James Gilbert here on behalf of Mr. Chapman, who's standing to my right.
All right, and we're here for docket call. What's our status here?
Your Honor, we do have a plea agreement. We've discussed it. I have discussed it with my client. We are asking if we could have the February date, and at that time, we'll tell you whether we're pleading or going to trial.
All right, let's continue with any objection, Mr. McLean?
No objection.
February 2nd at 10:20. We'll use that as a plea or a plea cutoff date. And anything further from the defense then?
No, Your Honor. Thank you very much.
People?
No, Your Honor.
And Mr. Chapman, we'll see you then. Thank you. And that brings us, Mr. Gilbert, to people be Selena Valentine.
Yes, Your Honor. I know she's scheduled for 10. I haven't had contact with her. There is a
Maybe we should
concern.
pass the case till then, since there's show causes and I actually, since then, she had failed to report and I've issued bench warrants for her and both those as well. So I'm sort of expecting that she won't appear. Well, I guess we don't need to recall it unless she does appear.
Okay, all right. That's my
But
concern.
it's already in warrant status. So I mean, we could do another warrant for her failing to appear today, if you wish. And then we'll leave it without date and warrant status unless and until we get her in custody. If she does appear today, let me know and we can recall it and see where we're going on.
Excellent. Thank you.
Mr. Vogler, we're a little ahead of schedule, but we've got, Sean Hoffman's in jail.
Right, sheet, that would go quicker.
Okay, it's called People v. Mariah Cheat. It's file 25-3358FH for docket call. We're scheduled for a trial in March, and there's been some discovery issues. Where are we at with all that, Mr. Vogler?
So where we're at is that there's been a plea agreement reached. The agreement will require we're stipulating that the court remanded to the district court for entry of a plea to a misdemeanor with a sentence agreement down.
Mr. Wergo, is that correct?
Absolutely, Your Honor.
All right, so we'll remand that case to 89th District Court for plea taking, take it off the trial docket. And Jerry, if we can, we'll prepare a judgment. And then, so then because you both have placed it on the record, I don't need you to submit a written step. We'll just do a judgment of remand from the court.
All right, thank you. Thank you, Your Honor.
Go off the record for a second.
do not see any additions or corrections.
And the, looks like the advisory guidelines at the original sentencing had been scored at 5 to 23. Any reason to revisit those guidelines?
No, Your Honor.
Mr. McLennan, any additions, corrections, or scoring challenges from the people?
No, Your Honor.
All right, Mr. Gilbert, go ahead.
Your Honor, I've known Mr. McGrath a long time, and that's probably not a real good positive thing to say that, you know, he's known me a long time based off of my occupation. But in the course of that time period, I've gotten to know Mr. McGrath, and he does make some stupid mistakes, and that's what it is. It's dumb mistakes. It's not, he's not what we call a hardened criminal. He's doing this just out of spite or to thumb his nose at the law. He makes stupid mistakes. And again, that's what this one was. I know he's a very remorseful young man. We are in support of the recommendation, or even if the court would consider time served. He has served quite a bit of time. One thing he has done actively while in jail, and I'll ask to approach or have the bailiff give these to you, is he's partaken in any course that he possibly can, whether that be for counseling for his substance abuse issues, whether it be in a religious standpoint. One of the authors of one of those letters, Dale DeVerding, is here in the courtroom. He works for the county as a patrol officer or a recreational officer. He also operates a church locally. I know Dale quite well, and he has told me about what they're willing to do to help Mr. McGrath stay on the straight and narrow and establish a support network for him. One of the things he does want to do once he gets his commitment to you taken care of is go to Missouri. Dale's telling me that they actually will help him get there because they believe that he probably even has a better support network there to accomplish the things and keep Mr. McGrath from falling back and being back in front of you again or making other stupid mistakes. And I would ask the court to consider all these things that he has been doing and possibly give him time served. But in any case, we're in support of the recommendation. Thank you.
Mr. McGrath, you don't have to say anything today. You're welcome to. Is there anything you want to tell me or no?
I am sorry, and I did make stupid mistakes, and I am remorseful, and I would like to change. I'm working towards change for the better.
Thank you. Mr. McLennan, any recommendations?
Yes, Your Honor. Doing the PSI in this matter and the probation violation report, it appears Mr. McGrath does have a substance abuse issue. Part of his terms of his probation was to have an assessment done and get treatment for that. And he did have the initial assessment done and was referred to outpatient treatment services. However, he did not go to them. Eventually, he did set up an appointment, but was arrested prior to being able to go there. The report indicates he hasn't made any payments towards the costs he owes. And he was supposed to be reporting on probation in Sheboygan, and he missed 3 of 3 appointments there. I would say that since he's been in jail, it looks like he's been doing some good things, but Your Honor, based on, I would say it's a failure of his compliance on probation. I think the appropriate recommendations are appropriate in the report for 6 months of jail, Your Honor. Thank you.
Well, Mr. McGrath, you know, I do agree with something your attorney said that, I mean, I know you well as a graduate of our recovery court program. You're not a malicious guy. You know, I do agree with that. There is a troubling pattern here over the last 10 years. In 2015, you got a OWI in Texas that was pled down to obstructing a highway. And then your probation got revoked and you got 2 months in jail. In 2016, you got domestic violence in Las Vegas. You got probation, but then a bench warrant for failing to appear. I think that's a still open case. 2017, a possession of marijuana, 6 months jail, but there had been a possession of other narcotics that was dismissed as part of a plea. And then in 2019, a meth lab case, and instead of prison, you got recovery court. And you didn't go to prison, or I mean, you had some credit for before the sentencing, but you didn't get jail or prison for that. You got treatment court. You did well in the treatment court. I remember talking with you about, you know, your employment and your progress. And, you know, I felt really good about where you were at, and I'm sure you did too. And then you graduated in 2021, December 2021. And then this year, you got a felon in possession of a firearm with 5 to 23 months guidelines range. Another possible prison case. So you had a definite prison case in the meth lab, and I didn't send you to prison. You got treatment court. You had a possible prison in front of me in April, and I didn't send you to prison then. And I didn't even give you jail then. Do you remember why I didn't give you jail?
Yes.
Why?
Because I did good, so that I go drug court and because.
The job.
Yes, sir.
I said I didn't want to disrupt your long-standing employment that seemed to be the most stable thing you had in your life. Within a month after I made that decision, you quit that job. Oh. And you haven't paid a penny on the fines and costs. You made excuses to reschedule your reporting days, every one of them you had, which makes me think you were trying to avoid detection for drug testing. You continue to use drugs. We ordered you to treatment. You didn't go to treatment. And then you drove while high less than 6 months after I put you on probation. You've stood in front of me twice when prison's at the plate and you didn't go. Is strike 3, Mr. McGrath. You're going to go today. I'm revoking your probation. You have not complied with the efforts that we've given recently to get you on a better track. And now that you're in trouble, you're going to classes in the jail. Yeah, good on you. And I got no doubt that you're well-intentioned with that. The problem is when somebody doesn't have the screws right to you, you just do what you want. Those guidelines arguably don't even take into account your poor progress on probation, but I'm not going to exceed those guidelines. You avoided prison in 2019 due to recovery court. I gave you another chance of no jail in this case. You squandered that opportunity. Now it's just time for time. So I'm revoking your probation. I'm going to commit you to the Michigan Department of Corrections for a term of not less than 18 months or more than 5 years. Give you credit for 125 days previously served. That's within the advisory guidelines. It's not even at the top end. I do think it's proportionate given the circumstances of this offense and the offender. Fines and costs remain due and owing in the amount of any unpaid balance. And Mr. McGrath, if you wanted to appeal, you can do so by filing an application. We're going to hand you a piece of paper about that. Ask you to initial one copy for us. The other one's for you to fill out if you want to take an appeal. And did you parole out? You know, hopefully they can transfer you out to Missouri, and I hope that you make some better choices in the long term, Sean. And I wish good things for you. Maybe you don't believe that today, but I do. Good luck. Mr. Hoffman.
Mr. Hoffman, Your Honor, yep.
This is People v. Sean Hoffman, file 25-93368FH. For docket call, counsel, you want to state your appearances, please?
Chairman, I'll forward on behalf of the people.
Your Honor, Mike Vogler representing Sean Hart.
And we're here for a docket call, and it looks like we are scheduled for jury trial in 2.5 weeks, Thursday, January 22nd. Is that still our plan, counsel?
Yes, Your Honor. Yes.
All right, the witness and exhibit lists have been exchanged. I take it then. Any pretrial issues that we need to address today, Mr. Vogler?
Yes, there is an evidentiary stipulation. And the stipulation is that none of Mr. Hoffman's responses to police questioning that occurred from the time he was arrested doorsteps of the house till the time he was provided Miranda, which occurred in the police car. Those responses would not be admitted. There would be another statement in which this was after Miranda, but in which Mr. Hoffman indicated or that he was a convicted felon. That would not be admitted. And there was another statement that he made while being booked, again in a back and forth with the police officer, to the effect where he mentioned that he had been a prisoner. I think those statements of his would not be admissible. There are multiple body cams. I don't anticipate the prosecutor is going to be introducing body cam footage of situations where the police are simply talking to each other. Things, I don't think any of.
So, Mr. Wergo, you agree that the statements that Mr. Vogler outlined are not going to be admitted during trial?
Yes, Your Honor.
And do you have clarity on what those statements are?
I do. We almost down to the word, Your Honor, and it's not my intention to actually introduce anything that has any audio of Mr. Hoffman's statements.
And in terms of any testimony about the statements, you'll instruct any of your testifying officers about the limitation that you've agreed to there?
Yes, Your Honor.
Okay. All right. Any other evidentiary issues to place on the record?
No, Your Honor.
Just that it has been recently disclosed that the defense might be seeking to amend their exhibit list relative to defendant's clothing at the time of arrest. I don't have any issue with that so long as there's no specialized use for them, some sort of where I would have to have a lab report or something like that, Your Honor. But if it's just what they look like, texture, things like that, I wouldn't have any objection to allowing the clothing to come in as an exhibit.
Okay. All right. Anything further from the defense then?
No, Your Honor. And everything else.
From the people?
No, Your Honor.
Anything? That's it. Well, thanks.
Okay. Okay, the 180-day rule, Mr. Hoffman, applies if you were a prisoner in the Department of Corrections, and so it's not applicable to a pretrial detainee in the county jail. We do have your trial scheduled.
It's MCL though.
Yeah. All right, so we've got your jury trial scheduled for January 22nd. We'll begin with jury selection at 9 a.m. sharp. I'll see counsel in chambers, say 8:30 or so. I'll be around and we can just touch base on where we're at. And Mr. Vogler, you'll make sure that Mr. Hoffman's arranged for street clothes.
Well, I've indicated that to him. He needs to. I guess I'll have that discussion again, but I'm assuming he has street clothes available to him, not in the jail presently, but someplace.
We'll make sure, Your Honor, we got jail closed down there.
Okay, and we'll have him, there's been no motion for any restraints or shackles, so he'll be in the courtroom unrestrained during the trial. Okay. All right, we'll see you then the 22nd, Mr. Hoffman. Brings us then. Go off the record for a second.
felony advice of rights due to the nature of the plea.
Do you have an amended information? The use?
Yes, Your Honor.
Sir Gilbert, you consent to the filing?
I do, Your Honor.
All right, Ms. Gagnon, I have a plea agreement in front of me that would involve you pleading guilty to counts 2, 3, and 4 and amended information. I have to tell you the maximum penalty involved for those. Count 2 is operating without security or insurance on the vehicle. It's a misdemeanor punishable by up to a year in jail and or a fine of $200 to $500. Count 3 is operating while your license is suspended or revoked. That's a misdemeanor punishable by up to 93 days in jail and or a $500 fine and possible vehicle immobilization. And count 4, use of methamphetamine, is a misdemeanor punishable by up to a year in jail and or a $2,000 fine. Do you understand the maximum penalty that you could face?
Yes, Your Honor.
And did you read and sign the advice of rights form for misdemeanor plea?
Yes, I did, Your Honor.
Do you understand all the rights listed on that form?
Yes, I do.
Do you have any questions for me or your lawyer about any of those rights?
No, I don't, Your Honor.
Do you understand if you enter this plea, you give up all those rights?
Yes, sir.
And is that what you are choosing to do today?
Yes, Your Honor.
The plea agreement provides in exchange for your plea to those charges, the felony possession of methamphetamine, count 1 will be dismissed. Do you understand that plea agreement?
Yes.
Has anybody promised you anything else?
No, Your Honor.
Has anybody threatened you?
No, Your Honor.
Is it your own free choice to enter that plea?
Yes, Your Honor.
Mr. Gilbert, are you aware of any other promises, threats, or inducements?
I am not.
Mr. McLennan?
No.
All right, Ms. Gagnon, knowing all this, how do you wish to plead in count 2 to operating vehicle without insurance?
Guilty.
Count 3, operating vehicle while your license is suspended or revoked?
Guilty.
And count 4, use of methamphetamine?
Guilty.
So, Ms. Gagnon, back on May 24th of this year, were you in Presque County?
Yes.
Were you operating a motor vehicle, a Chevy Cruze on M68, a public highway?
Yes, Your Honor.
Was that your vehicle?
Yes.
Did it have insurance on it?
No, Your Honor.
And you knew it didn't then?
Yes, Your Honor.
Was your driver's license suspended?
Yes, Your Honor.
And you knew that?
Yes, Your Honor.
And did you have in your possession methamphetamine?
Yes, Your Honor.
Did you have any lawful authority to possess it?
No, I did not.
Right, and that establishes the lesser use. Mr. Gilbert, you satisfied with that factual basis?
I am, thank you.
Yes, Your Honor.
All right, well, Ms. Gagnon, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe that you're guilty of those offenses. So I hereby accept your plea. Misdemeanor plea being entered. Any objection to immediate sentencing?
No, Your Honor.
No, Your Honor.
Mr. Gilbert, anything you want to say on the client's behalf?
Your Honor, in regards to Ms. Gagnon, I am very impressed with everything she has accomplished while on bond. This court, the one day said to her, if you're having issues, you should reach out to your lawyer and get into some sort of rehab. Within days, she took the court's advice and she was in a rehab because she was having issues and she was struggling. She completed that successfully. She's now working on getting her GED and is hoping to go forward and with further education after obtaining that GED. You gave me the date. Tiffany, what date was it? Was the last day of your use?
May 25th.
Is and that's a date that she's very proud of. That was the last time she used. I would ask the court to take all that into consideration. I know she's been working to stay with her children or keep her children, and I believe she's doing well in that arena also. So I would ask the court to sentence her to fines and costs if the court would be willing to. Thank you.
Okay, thank you, Ms. Gagnon. You don't have to say anything, but you're welcome to. Is there anything you want to tell me?
I did start my GED while I was in rehab. I will be graduated at the end of January. And then my goal is to do business management. I've done everything that I can to maintain my sobriety, and I realize that I'm doing a really good job. I'm staying at my mom's. I'm on a very short leash there, but that's what I need. And I feel like I'm doing pretty good.
Okay, are you working right now?
I am not, but I am seeking employment and I'm in school. So it's hard right now. That takes up like 8 hours of my day. So.
Okay. All right, Mr. McLennan, any recommendations for people?
Yes, Your Honor. Ms. Gagnon seems to be on the right path right now, having gotten her GED and being in school. She had a little hiccup with marijuana and some whiskey she admitted to using. She did have an abscess tooth. She has no prior felonies. This is, as far as we're aware, her first substance abuse issue, criminally speaking. The people would support a term of probation in this matter. Thank you.
Thank you. Well, Ms. Gagnon, I'm glad that you've used this case as an opportunity to get some things on a better track for you, for sobriety, for becoming the best mom that you can be, getting your schooling done, looking for work. Those are all positive things. So you having entered a misdemeanor plea today, I'm going to sentence you to fines and costs only. I don't think that any jail would be necessary or appropriate in this case. Given that you're not working now and some of the things you have going on, I'm not going to assess the court costs. So that'll save you $350 right there. There is a $50 minimum state cost for each count and a $75 crime victims assessment and a minimum fine of $200 on the no security. So by my math, that's a total of $425 in fines and costs. Can you do that today? Then you want to set up a payment plan with the clerk's office.
Yes.
That'll be the judgment of the court. You can file an appeal if you wish by filing an application of the Court of Appeals. If you want a lawyer, we'd have to ask within 6 months. I know you're shaking your head, you don't want to. I have to tell you, you have a right to do that. And hand you a piece of paper explaining the appeal rights. Ask you to initial one copy for us and once for you to fill out if you like. Good luck to you.
Thank you.
Thank you very much, Your Honor.
So go over your last matters, Mr. Stoneham.
Yes, Your Honor, if I can just have a few moments with, he's ready to go we're just waiting for the AG to get us a plea.
Oh, okay. Let's go.
Just a recommendation.
Okay. Any additions or corrections to that report?
No, Your Honor.
And the guidelines are scored at 0 to 17 months. Any scoring challenge?
No, Your Honor.
Any additions, corrections, or scoring challenges from the people?
No, Your Honor.
And Mr. Hartman, go ahead.
Your Honor, I think the PSI does a fairly good job of capturing a little bit about what's happened with Mr. Bogner. As is quite common, Your Honor, he got introduced into drugs to medicate legitimate injuries stemming back from having migraines from a child to 2005 having a snowmobile accident. He is on disability and has been since 2017. And Your Honor, I'd like to first address the second case in this situation. When they arrested him, he had a pill bottle that had muscle relaxers that were not prescribed to him. It had ibuprofen, and in there was an Oxycontin that was kind of given to him as he was trying to treat his pain without having the resources and ability. Mr. Bogner had, while this case was pending, expressed a desire to get into treatment. Unfortunately, because he is on disability and above 60, what ends up happening, he has Medicare instead of Medicaid. One of the challenges with Medicare is they don't pay for residential treatment, so only outpatient was available to him. Your Honor, I do believe he is a person that can, with proper pain management and controlled substances that are focused on muscle relaxers and maybe some nerve pain and some other additions. He needs to have a full medical workup. He needs to have he has the underlying history, which is set forth, I think, pretty accurately in the report related to his physical ailments. If you look at that section of the different problems, he survived a stroke and other issues. The writer of the report indicates that he had no minimal law enforcement involvement until 2017, when all of his stuff is related to drug use, Your Honor. I note that this court does not have a drug court. If it did, I believe he would be an excellent candidate for it. Unfortunately, that is one of the challenges that we have here. Your Honor, I'm asking if the court would consider, instead of the incarceration, which is warranted, I'm not suggesting the recommendation is out of lines with the norm, but in fact, that since this court does not have a drug court, I am asking, and since he can't get into residential treatment, that the court consider holding treatment in abeyance. I'm sorry, holding some of the jail in abeyance and making sure he follows through with treatment. His Medicare will allow him to do outpatient treatment, and he can start a course of program and get into outpatient treatment and follow that. And I don't know if he would be eligible for Swift Insure since he's not a prison candidate with his recommendation, but a 0 to 17 guideline with a focus on rehabilitation seems to be what is appropriate in this case. While, Your Honor, against rehabilitation, of course, is the fact that he's a repeat offender. I would note, Your Honor, that this is a crime of substance use, and our criminal justice system has viewed repeat offenders in that slightly different than people who repeat crimes of violence or crimes of theft. I am imploring this court to give him a dose of jail. I recognize he did have a pill on him while he was reporting to jail or being arrested, and that was one of the complicating factors in this case. I would ask the court to consider a much shorter upfront jail time, hold the majority of it in abeyance, and see if he can get his medical and his treatment in line and come up with a plan that will be successful. Your Honor, I do note that he received successful treatment through Thunder Bay previously. But what he really needs is something like an opioid home health program, which integrates both his medical treatment with his substance use treatment, and it would require a little bit of a novel approach. Your Honor, I would just ask if he was across the border in Sheboygan County, what type of sentence the court would have available in its disposal, and if the court could fashion something similar. We do acknowledge he is guilty of both crimes. We've not denied that. We're just asking that you recognize that we'd like to focus on him improving his life, because he has indicated at 60 years old, he does not want to be in the criminal justice system. He does not want to be addicted to drugs, but he does want to manage and control his pain in a legal and lawful manner.
Thank you, Mr. Hurt. Mr. Bogner, you don't have to make a statement today, but you're welcome to. Is there anything you want to tell me, sir?
I guess I'd like to get some treatment if I could. Other than that, I really don't have any more to say.
Mr. McClellan, any recommendations from people?
Yes, Your Honor. Mr. Bogner is 60 years old, has 3 prior felonies and 3 misdemeanors. In this case, he pled guilty to possession of cocaine. That'd be his 3rd controlled substance felony conviction, as far as the people are aware. Cocaine pipe in his vehicle with cocaine residue on it. And then later he was found with a oxycodone pill. So he does have some substance abuse issues. I would note he was on probation 2 previous times for possession of meth, patient treatment both times. Noted PSI, he stated he didn't feel that he needed treatment. He was only attending because of court. Your Honor, clearly he does need some treatment, and we're hoping there's some success with some treatment, but it hasn't been too successful. I do think some upfront jail time is appropriate, Your Honor, and if there is a way to build in treatment, we would support that as well. Thank you.
Thank you. Well, Mr. Bogner, I think the comments of your attorney recognize, there's a lot of things going on here. One that's the substance abuse issue we want to try to focus on treatment as a possibility. You've been on probation with me before, and that didn't go super well. And so, I mean, you've been ordered to treatment before, and also, like, You don't have to wait till you get arrested and the judge to tell you to go to treatment, People go on their own all the time. People get sober every day in America.
Yeah, I've tried. I can't get in. And they won't take me.
I'm telling you, people get sober every day in America that aren't ordered to by a judge.
Yeah, I know.
You know, when people come to me at sentencing and say, please, judge, give me treatment, it always kind of, I don't understand that. Like, you don't need me to give you treatment. It's available out there in the world for you to have. I'm going to order you to do it. You know, and the recommendations for you to do 6 months, it's 0 to 17 guidelines range under the criminal justice reforms. I'm required to consider no incarceration unless there's reasonable grounds to do so. There are some reasonable grounds here, being that it's your third drug conviction in the last 4 years. Really mitigating against that is, you know, the case that I'm sentencing you for today is a residue case in a car with it's an unregistered vehicle, unlawful plate, and residue. There's no high risk of public safety concerns in this case. So I think on the whole, taking all those things into account, including your prior record and the information in the pre-sentence report, there's some fines and costs here. There's state costs of $168 for the 3 counts, $130 crime victims assessment, court costs of $350. We'll place you on probation on the felony charge, and there'll be a monthly supervision fee for that. And it'll be subject to all the terms and conditions listed on pages 2 and 3 in the pre-sentence report. Chief among them, of course, is to complete treatment as ordered and not use or possess alcohol-controlled substances and be subject to testing. And I think some jail is appropriate, but I agree, given the total circumstances, not the 6 month. I'll order you serve 2 months in the Presque County Jail, give you credit for 2 days previously served. Within 24 hours of your release, you have to contact Agent Lesky to get going on your probationary term. And Mr. Bogner, if you want to appeal, you can file an application to the Court of Appeals. If you wanted me to appoint a lawyer, you'd have to ask me within 6 months. We're going to hand you a piece of paper explaining that process, ask you to initial 1 copy for us. The other one is for you to fill out if you wish to take it. Do you have any questions for me, sir?
No.
Okay, good luck to you.
Probation form too.
Oh, yeah, and you're eligible for early discharge of probation at the halfway point. It's a 2-year term, so after 1 year, you can petition for discharge if you successfully complete the terms, and we're handing you a piece of paper explaining that as well.
Okay.
Good luck, Mr. Shirley.
How long was the probation?
He's got that. Good on revising.
Yes.
Can you hear me?
Yep. Just waiting for Mr. Williams there. All right. All right, good morning. We're back on the record in the 53rd Circuit Court for the County of Presque. As a reminder,
Let me change my speaker input.
You're not hearing me? Can you hear me? Can you hear me, Mr. Williams?
Yes, Your Honor.
Oh. Reed, can you hear us now? All right, I'll tell you what, I'm going to remove Miss Reed, let her zoom back in. Sometimes that helps. I'll put you back in a waiting room until we get her back in.
Okay.
All right, well, Mr. Williams, what's our plan here today?
The plan was to put a plea on the record of criminal sexual conduct, 4th degree. I'm sure we're gonna need Ms. Reed's participation.
Yeah.
Do you want to I mean, I'm available if you want to reset it, like,
Well, here she's trying to zoom in on, she's trying to connect on an iPhone, I think. So let me remove her and see if that'll work. All right, is that better, Ms. Reed? Can you hear us?
Yes. My
Okay.
apologies.
All right, and now Mr. Williams seems to have frozen.
I couldn't get audio.
Yeah, we could hear you. All right, and
But
now
I
we-
switched. Okay.
Mr. Williams, can you with us again here? We lost you for a minute.
yeah, I don't know what's happening. Yes, I'm here.
All right, let's give this a try. I was about 2 seconds away from just scheduling this for an in-person plea. So let's keep our fingers crossed here that we can get this done. People v. Alex Harimoto, file 25-93378FC. Counsel, you want to state your appearances for the record, please?
Beth Reed appearing for the as a special prosecutor.
Jesse Williams representing Mr. Harimoto.
Okay, and Mr. Harimoto is appearing by Zoom video from a separate location from Mr. Williams. Let me know at any time if you need a breakout room to talk confidentially. We're here for a docket call, and I'm told there's a plea resolution here. Do we have a written plea agreement? Has it been sent to the court?
Yeah, the agreement is he's pleading guilty to 1 count of criminal sexual conduct, 4th degree. And upon successful completion of that, the balance of the charges will be dismissed.
Okay, but we don't have a written plea agreement, Jerry? Do we have an amended information? Ms. Reed, would you submitted an
Your Honor.
amended information?
No, Your Honor, but I can generate one and email it to the court right now.
No, I think we. No, here's what we're going to do. February 2nd at 10:40 a.m. I'll have everybody present in person for a plea hearing. I want the amended information done ahead of time. I want the written plea agreement. I want a written advice of rights. We're not going to have tech issues, and we're going to have all our paperwork ducks in order. I'll see everybody in person in my courtroom February 2nd at 10:40 a.m. All right.
Yes,
thank
Your
you.
Honor.
All right, thank you, Your Honor.
Thank you, Your Honor.
All right, I see the Attorney General, Mr.
Awesome. Great.
All right, good morning. We're back on the record in 53rd Circuit Court, and up next, we've got People v. Manson Stoneham, file 25-93369FH. Counsel, you want to state your appearances, beginning with the People?
Morning, Your Honor. Carrie Angie on behalf of the Attorney General's office.
And good morning, Your Honor. James Gilbert here on behalf of Mr. Stoneham.
All right, good morning. We're here for a docket call, and I have in front of me a plea agreement. It includes a sentence agreement, so I could be guilty to count 1, the dismissal of count 2 and the habitual enhancement. Is that right? It's just for the 1 count.
That's okay. That's correct.
And there's a sentence agreement for a delay of sentence. If the arrears are reduced to 8,300, then be reduced to 1 count of an attempt. If the arrears is reduced to 0, then be reduced to a disorderly person. Is that how you want to proceed today, Mr. Stoneham?
Yes, sir.
Would you raise your right hand for me, sir? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You put your hand down. Mr. Stoneham, a guilty plea hearing is an important event. It includes the waiver of constitutional rights that you have. So therefore, I want you to listen carefully. At any time, if you have a question, just ask me. I'm happy to answer it. If you need a minute to talk to your attorney, you just let me know as well. Now, I have to advise you the maximum penalty that you face for the charge. Failing to pay child support, count 1. It is a felony punishable by up to 4 years in prison. It's a felony punishable by 4 years and or a $2,000 fine. Do you understand that maximum penalty, sir?
Yes, sir.
Are you on probation or parole anywhere?
No, sir.
Were you on bond for any other felony case at the time of this incident?
No, sir.
Did you read and understand the rights listed on the advice of rights form?
Yes, sir.
Do you have any questions for me or Mr. Gilbert about any of those rights?
No, sir.
Do you understand if you plead guilty, you give up those rights?
Yes, sir.
And is that how you wish to proceed today?
Yes, sir.
If I accept your plea, you can't come back later and tell me that it was caused by any threats or promises beyond the terms of the plea agreement. Do you understand that?
Yes, sir.
Also, when you plead guilty, you lose the right to appeal. And if you wanted to appeal, you'd have to seek permission by filing an application. But the types of issues you could raise on an appeal after you plead guilty are very limited. Do you understand that?
Yes, sir.
Okay, and the plea agreement, as I outlined for you, includes that sentence agreement, a delay of sentence, and then a reduction based upon the amounts that you reduce the arrears to. Do you understand that agreement?
Yes, sir.
Mr. Gilbert, is that a full, fair, and accurate statement of the terms of the agreement?
It is, Your Honor. Thank you.
Miss Ange, is that correct?
Angie, Your Honor. Yes, it is correct. I would only, thank you. I would only add that the defendant has agreed to reduce the arrears to $8,300 for the attempt. Is that accurate, counsel?
Yes, and that's in the written agreement. Yep.
Thank you.
All right. Mr. Stoneham, that sentence agreement is not binding on me. I don't have to follow it when we get to sentencing. If I decide I don't want to follow it, I don't have to. But if I didn't go along with the sentence agreement, you'd be allowed to withdraw your plea, not having received what you bargained for. Do you understand that?
Yes, sir.
There is an important exception to that, however. If you engage in any misconduct between now and the sentencing date, let's say by skipping court, absconding your bond, violating a court order, or committing a new crime, that type of misconduct would cause you to lose the right to withdraw the plea, even if I didn't go along with the sentence agreement. Do you understand that?
Yes, sir.
Other than this plea agreement, has anybody promised you anything to get you to plead guilty?
No, sir.
Has anybody threatened you to make you do something?
No, sir.
Is it your own free choice to enter that plea?
Yes.
Knowing all this, how do you wish to plead to the charge in count 1, failing to pay child support as ordered?
Guilty.
And Mr. Gilbert, would you assist with the factual basis?
I'd be happy to. Sir, can you state your name for the record?
Manson Stoneham.
And Mr. Stoneham, are you a resident of Presque Isle County?
Yes, sir.
And did you have a child that resided in Presque Isle County?
Yes, sir.
And you were ordered by the court to pay child support, is that correct?
Yes, sir.
And from the time periods of September of 2022 to August of 2024, you failed to meet those child support requirements, correct? Yes, sir. To the tune that you were in arrears about $16,500. Yes, sir. Granted, you paid quite a bit and you've got it down to less than 12,000 now, correct? Just under 12, sir. But at that point in time, when this was filed, you owed over $16,000. Yes, sir. I have no further questions, Your Honor. Thank you.
You satisfied with the factual basis, Ms. Sanchi?
Yes, Your Honor. Thank you.
And are you aware of any other promises, threats, or inducements?
None, Your Honor.
And do you believe that I fully complied with the requirements of MCR 6.302?
I do, Your Honor. Thank you.
Mr. Gilbert, do you agree on all those questions?
I do. Thank you.
All right, Mr. Stoneham, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe you're guilty of that offense, so I hereby accept your plea. We'll schedule sentencing for February 2nd at 10:30 a.m. And you'll have to cooperate with a pre-sentence report. So before you leave, talk to Agent Lesky, get her card so you can schedule an interview so she can fill out a report and recommendations for us. And Mr. Gilbert, any objection to allowing the Attorney General's office to appear by Zoom for that sentencing?
Not at all.
All right, Ms. Angie, your office can appear by Zoom for the sentencing hearing. The defense and his attorney will be in person.
Thank you, Your Honor.
Okay, anything further from the people?
No, Judge, I'd just like to thank the defendant for the efforts that he's made so far and encourage him to continue on that track.
Okay, very good. Anything further from the defense?
No, Your Honor, thank you.
All right, thank you. Have a good day.
Likewise.
All right, let's go off the record. All right, good morning. We are on the record in the 53rd Circuit Court. Are providing public access both in the courtroom and also online. And we rescheduled a hearing to have it heard sooner. It is People of the State of Michigan versus Franklin Elliott III. It's filed 25-7119FH. Counsel, you want to state your appearances for the record, please?
Melissa Goodrich, Blaine County Prosecutor.
No, negative. Mr. Elliott appears in person in custody to my right.
All right, good morning. And I've been handed a plea agreement, advice of rights, and amended information. Is that how we're proceeding today, Mr. Nightingale?
Yes, sir.
All right. Mr. Elliott, would you please stand and as best you can, raise your right hand for me? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Absolutely, sir.
Okay, you can have a seat back down. All right, Mr. Elliott, a guilty plea hearing is an important event. It includes the waiver of constitutional rights that you have, so I want you to listen carefully. At any time, if you've got a question, go ahead and ask me. If you have a need to talk to Mr. Nightingale some more, you just let me know. Okay, do you understand that?
Yes, sir.
Now, I have to advise you the maximum penalty that you could face for the charge that you're pleading to. Will Mr. Nightingale take consent to the filing of the amended information and waive its reading?
Yes, sir.
All right. So, Mr. Elliott, you'd be pleading guilty under an amended information to possession of methamphetamine as a habitual offender second notice. That's a felony crime. It's punishable by a maximum of, with the habitual, up to 15 years in prison and or a $15,000 fine. Do you understand the maximum penalty?
Yes, sir, Your Honor.
And are you on parole, Mr. Elliott?
Yes, sir, Your Honor.
So you understand that this would be mandatory consecutive to any parole violation sanction the Department of Corrections determines?
I understand, Your Honor.
And parole detainer's been filed?
He does have a hold, that's my understanding.
So you understand, Mr. Elliott, you are not entitled to credit for the time you've been sitting on the parole hold?
I understand that, Your Honor.
Okay.
Thank you.
Did you read and understand the rights listed on the advice of rights form?
I have, Your Honor.
And did you have any questions for me or Mr. Nightingale about any of those forms?
No questions, sir.
Do you understand if you enter a plea, you won't have a trial and you'll give up all those rights?
I understand that, Your Honor.
Is that what you're choosing to do?
Yes, sir, Your Honor.
If I accept your plea, you can't come back later and tell me that it wasn't your own free choice to enter it for any reason at all, including any promises beyond the plea agreement or any threats that you say were made to you. Do you understand that?
Yes, sir, Your Honor, I do.
By pleading guilty, you also give up the right to appeal. And if you wanted to appeal, you'd have to seek permission. You would do so by filing an application. But the types of issues you could raise after a guilty plea are very limited, much more limited than if you were convicted after trial. Do you understand this appeal limitation?
Yes, sir, Your Honor, I do understand.
All right, the plea agreement, excuse me, provides that in exchange for that plea, the prosecutor is going to dismiss the drug double and the habitual fourth enhancement. And there's a sentence agreement that any incarceration ordered would be within the Michigan sentencing guidelines. So it wouldn't be a departure one way or another. And also that the parties have determined the guidelines to be 5 to 28 months. If they're wrong about those facts and the guidelines end up scored higher or lower, then either side has an option to withdraw the plea if the guidelines are different than what they expected them to be. Do you understand the terms of that plea agreement?
Yes, sir, Your Honor, I understand that.
Okay, has anybody promised you anything else?
No, sir, they have not.
Has anybody threatened you in any way?
No, sir, they have not.
Is it your own free choice to do that?
It is, Your Honor.
Now, Mr. Elliott, that sentence agreement is not binding on me. If I don't follow it, you'd be allowed to withdraw your plea, not having received what you bargained for. Do you understand that?
Yes, sir, Your Honor, I understand.
Now, there's an exception to that. If you engage in any misconduct between now and the sentencing date, by any violation of court order or bond or committing any new crime, then by your misconduct, you would be losing the right to withdraw the plea, even if I didn't follow that sentence agreement. Do you understand that?
Yes, sir, Your Honor, I understand that.
Even, like if you engage in some misconduct and the guidelines end up higher and I don't follow the agreement and I give you the higher guidelines or even beyond the guidelines, then by your misconduct, you would have lost the right to withdraw the plea, even though this agreement says you can do so.
I understand.
Okay. All right, knowing all these things, Mr. Elliott, how do you wish to plead to the charge of possession methamphetamine habitual second?
I plead guilty to that, Your Honor.
So, Mr. Elliott, back on November 7th of 2025, were you in Sheboygan County?
I was, Your Honor.
And were you in possession of the controlled substance methamphetamine?
I was, Your Honor.
Did you know that you were in possession of that substance?
I did know that, Your Honor.
Did you have any lawful authority to possess it?
I did not, Your Honor.
And at that time, did you have a previous conviction for manufacture or distribution of an imitation controlled substance from 2005 out of this court?
I absolutely did, Your Honor.
All right, Mr. Nightingale, are you satisfied with that factual basis?
I am.
Are you aware of any other promises, threats, or inducements?
Sure.
And do you believe that I've complied with the requirements of MCR 6.302?
The court has.
Ms. Goodrich, do you agree with those answers on all three questions?
Yes.
Mr. Elliott, I find that your plea is knowingly, voluntarily, and understandingly made, and that there is good reason in both fact and law for me to believe that you're guilty of that offense. So I hereby accept your plea of guilty. We'll schedule sentencing for March 10th at 10:30 in the morning. And you'll have to cooperate with the Department of Corrections staff for an interview to write a pre-sentence report for us.
Yes, sir, Your Honor.
Anything further, Mr. Nightingale?
No, Your Honor, thank you.
Ms. Goodrich?
There you are. Thank you.
Okay, we'll see you then.
Thank you, Your Honor.
We'll see you in recess.
I'm gonna go ahead and call this one for today, everybody. So yeah, we broadcast every day at 3:00 p.m. Central Time, 4:00 Eastern Time, bringing real court cases with real judges. If you guys like this content and you're not a subscriber to this channel, please do me a big, huge favor and subscribe to this channel. I really, really appreciate it if you can help make this channel grow a lot faster. But that's it for today. Tomorrow is Judge Flores, I believe. Let me look at the schedule. Yeah, tomorrow is Judge Flores. So I look forward to bringing that to you tomorrow. So for now, ta-ta and ciao-ciao, and I will see you guys again tomorrow. Have a good, wonderful evening, and stay warm out there.